seated, quiet in the courtroom.
Calling number 22 on the list, Commonwealth versus Kelsey Fitzsimmons, docket number 2577, CR 311. Counsel, please identify themselves for the record.
Good afternoon, Your Honor. James Kutosy on behalf of the Commonwealth.
Hello, Your Honor. Timothy Bradle on behalf of Kelsey Fitzsimmons.
Good afternoon, Your Honor. Martha Tooley on behalf of Kelsey Fitzsimmons as well.
All right, good afternoon. Judge, can I ask as a preliminary matter, if Ms. Kelsey might be permitted to join us? Ms. Fitzsimmons might be permitted to join us at the council table.
No, I only do that for a change of plea, a trial, or an evidentiary motion to suppress, and I don't see why I should treat her any different. So the answer is she's here at your request, but no, I'm not going to let her sit in council. Otherwise, I have to allow that for everyone, and it presents a security concern. So I do it for one person. I have to be consistent.
All right, if I need some time with her, Judge, I'm just going to ask for it.
Which, of course you can. You can go talk to her.
Very good.
Okay, so this is on for trial assignment today. I indicated in the phone conference that we had back in October that we could try it anytime. So let's do that.
So, Judge, a couple of things on that. We think that's a little premature for several reasons. I have 3 outstanding discovery motions that we ought to talk about today, if that's all right with the court, that sort of are, stepping stones to getting ready for trial.
Have you filed?
Yes.
Okay.
So 2 of them were filed on August 26th.
Okay.
And the other one is, and I'm certainly happy to give counsel for Commonwealth some leeway. This was filed, I believe, last week, November 21st. And so if counsel needs more time on that one, I certainly don't have a problem with it. And I will grant you, I'll acknowledge, Judge, that Commonwealth's given me a pretty fair amount of information that we're going through. But as you can imagine, and as I know you know, that sort of begs further questions about more discovery.
Well, I have one motion here for specific discovery.
Well, Judge, we filed 2 motions on August 26th, and I have copies of them here.
And what are they entitled?
There's a motion for court order disclosure and release of arraignment, and there's a motion for the Commonwealth may well be in compliance with some of that or most of it, and so those are really the first ones, Judge.
What is that?
Sorry.
Okay. The camera is allowed in the courtroom, but it has to be silent. No exceptions. Thank you.
The first one is the motion for exculpatory discovery, and that is essentially a Graham McFarland request regarding certifications by the officers, whether there's any prior incidents. And that is a predicate to a Rule 17 for that, so that we have a good faith basis, if any, to file a Rule 17 for any further information. And my brother's telling me that that's fully complied with.
Okay.
And I'll defer to him on that.
Okay.
No, I think I complied with my obligations under the.
Okay.
As far as that first motion, there are things in there that in the first motion that I do not agree to.
Okay.
And we can go through them if we'd like, but other than that, we have a list of questions that we ask every potential witness or police officer.
Right.
Database, but that has all been complied with.
Okay.
But if he wants to talk about the first motion, I'm happy to do that. No action has been taken.
Which, when you say first, I've got 3 motions here.
Motion for exculpatory evidence.
Okay.
Exculpatory discovery.
So that's essentially what we're talking about, Judge, the Graham McFarland request. And, it's also obviously a Brady request as well. So I think it's more than just, Graham McFarland. It's any exculpatory evidence that's known to the Commonwealth, whether it's the Commonwealth prosecution team or the police team as well.
So, Mr. Gubitosi, the motion for exculpatory discovery.
Yes.
What is it that you object to?
I object to number 1C,
Okay,
Number 1, D, number 1, H, I,
okay, hold on.
and J.
C, D, H, I, and J.
And then that's on number 1.
Right.
Number 2, he wants me to certify in writing that I have made inquiry of every prosecutor in my office for all items and information favorable to the defense. I don't think I have an obligation to do that.
Right.
We did that on every single case. We do have a database. We do have a process. We do ask each individual officer these questions, but we do that on every single case
Right.
in the county. That's thousands of cases to some 80 some odd prosecutors.
Right.
Every day.
Well, and it doesn't include all of the prosecutors that have passed through the office, that have come and gone over the course of the years. Are you suggesting, Mr. Bradel, that the Commonwealth needs to contact each and every prosecutor that has ever worked in the district attorney's office throughout the officer's tenure?
No, Judge. I'm
Well,
not.
that's what the motion asks for.
No, it doesn't, Judge. It asks them to have, maybe they could use a computer database. Maybe they can log, just like, lawyers have record-keeping responsibilities. Lawyers have conflict checks. There's all sorts of things that are precedent for this kind of a thing. When a prosecutor has a case where some questionable police activity has arisen, prosecutors can easily document that in this case, Officer Jones was found to be not credible by Judge Smith.
Well, I understand that,
Be
but
logged.
let me start with I. Whether the officer has signed a search warrant, I probably see 2 Frank's hearing requests a month in this session, 2 or 3. Most of them are not allowed. Occasionally they are. And just because there is a Frank's hearing does not mean that there was a finding that anyone gave any false information.
Sure.
So how would anyone determine that?
Well, Judge, again, these are record-keeping requests. And
But who keeps a database of that
so
for the last 10 years?
when you're a prosecutor in a district attorney's office and you finish a case, you're required to follow office procedures to close out the file.
Right.
And there's no reason why a prosecutor's office ought to exercise willful blindness about these issues.
So you feel that it's up to you to decide how the district attorney's office conducts its business?
It's up to me to decide.
Did you work in the Essex County DA's office?
Judge, I did not work in the
Okay,
Essex County
so
DA's office, but I do
From
know a
when,
little bit about it.
what are you speaking about when you say that this is how a DA's office ought to be conducting itself? What's the basis for that?
Judge, okay. I don't think it's a obscure proposition, Your Honor, that when a public agency such as the district attorney's office has to close out a case, that they have to comply with record-keeping obligations under the law.
But
Under FOIA, under record-keeping for all sorts of things about what happened with the case.
Well, I understand, but Mr. Gubitosi has represented that he's gone back and searched. They have a process. I'm sure that he'll advise you as to what the process is. And if you want to critique the process, that's up to you. But in terms of them producing evidence that is in their possession, custody, and control, he can only produce what he can search for. And the fact that you disagree, maybe you do, with the way in which they keep records or the type of records that they keep is not an issue that I'm going to decide. I don't know of any case law that says that I'm the one, or you for that matter, to decide how the district attorney's office keeps records. And in fact, I'm not going to order anybody to retroactively go back and search records from, I don't know how long the officers who are witnesses in this case have been police officers in this county, but do you know, Mr. Gubitosi, off the top of your head?
And then one of them is 20-something years ago?
Yeah, so I'm not sure that I can ask them to search records they don't have, but there is whether the officer has ever attended or presented at a law enforcement training by the private vendor.
Just before we jump off of that one,
Yeah,
all the Commonwealth has to do is ask the officers. There's 4 officers that were at the scene. They can ask 4 officers, were you ever involved in a Frank's hearing? There are ways to do this. We don't have to act like this is some obscure thing, Your Honor. This is exculpatory evidence. We have every right to all these things under Graham McFarland and under Brady. Kyle
what
V.
what
Whitney.
case says you have a right to find out whether any police officer on any case has ever refused to answer questions?
A police officer in our case, Your Honor.
No, in this case, what is the precedent? You've got to cite, where is the case or statute that says that a police department has to disclose to you or to anyone else when an officer declines to answer questions? There are a lot of reasons for that, I can assure you. And I'm not aware of any records that are kept of that. And I can assure you that it would never be admissible under any circumstances. So I'm having a hard time with the concept that the DA's office or the police department has to supply you with the fact that an officer 15 years ago declined to answer questions after a shooting at the scene, but 2 days later answered the questions, for example. Happens quite frequently. So I am reluctant to say, I doubt there's any police agency that keeps records like that. I don't know of any, but certainly the district attorney's office doesn't keep records like that.
Your Honor, I certainly am not telling you anything you don't know, but just put it out there on the record. When an officer takes the fifth, so to speak, it's been found that a truthful answer would incriminate them. So it's incriminating information.
Who's made that finding? That's an interesting concept because I probably represented thousands of officers at interviews, and I yet to have or even hear of someone making a determination that that person had a Fifth Amendment privilege or not. My experience has been that the department offers people a rights form, and if the department has made or ascertained that the person has a self-incrimination right, far be it from a lawyer to question that when the prosecuting or investigating agency is doing that. So again,
It's built into the law of the Fifth Amendment, Your Honor, that you can only take the Fifth Amendment when a truthful answer will incriminate you.
that's assuming you're ordered to, and that's assuming that the order also encompasses the nuances presented by the state constitution, which requires transactional immunity to overcome it under Carney versus Springfield. So it's not as simple as you make it sound. But let's get back to the fundamental issue. Does the district attorney's office keep records of any officers that have ever invoked their rights at any proceeding that the district attorney's office is aware of?
No.
Okay. And if, with regard to the police department, Mr. Bradel, I'm not aware of whether they keep records of that or not, but I am certainly familiar with the fact that even if that were true of a particular officer, it certainly is not admissible.
Judge Graham McFarland has a whole host of things that are not admissible, or an optimistic defense counsel
Right.
might say not yet admissible, but that's not a exclusionary factor, Your Honor. So you can't really go there. And these are all, we don't need to pretend like the officers are in Alaska. They're down the street.
No, I
The
understand.
Commonwealth can ask them all these things.
But does that case say that all records pertaining to an officer, any officer who has ever invoked his or her rights, either under the Fifth Amendment or Article 12, records have to be kept and they have to be disclosed? Does the case address that?
It does not say anything about.
Does the case address whether or not an officer who is the subject of a pending internal affairs investigation unrelated to the matter that is before the court, that those records need to be produced?
Yes.
Okay. And what about whether the officer has ever testified in a motion to suppress, which the motion was allowed because the officer it's pretty broad in terms of violating the defendant's rights, but assuming we could refine it a little bit,
Sure.
does the case say that you must produce that? And who's charged with keeping those records?
Your Honor, Brady says we have to produce that. The Constitution says we have to.
On any motion to suppress that was ever allowed?
If an officer is found to be not credible,
Well, see, we're talking.
Well, hold
about-
on, those are two different things here. The fact that a motion to suppress is allowed does not necessarily mean that an officer was found to have lied or made false statements. There are two different things. People make mistakes. The purpose of the exclusionary rule is to deter police conduct, but not every motion to suppress is allowed because a judge finds that an officer lied. Yes, the motions are allowed because in the court's judgment, for example, a stop was unjustified, but that doesn't mean that the court found that an officer lied.
that's.
In fact,
not
I'd
what
say
we're
most
talking
of the time, that's not the case.
We're not talking about a legal ruling about an officer's conduct. We're talking about when an officer's been found not credible. And that's what we're looking for, Judge.
Well, does your office keep records of decisions by judges saying that officers made false statements or are not credible?
Yes.
Okay,
And so,
Yeah.
and he's being cute, because what he's writing in this motion is much different than what he's saying here.
did you check the database for what I just
Yes,
outlined?
and we asked these officers, and he knows this, we asked these officers a whole host of questions.
Okay.
About whether they have any convictions, or convictions to
Sure.
facts about criminal offenses, I'll just, adverse credibility findings against them from any court.
Okay,
Pending criminal investigations into your conduct, findings that you have engaged in bias, racial, or
Okay.
profiling, discrimination.
Okay.
crime. Findings that you have engaged in untruthfulness or misconduct implicating credibility.
and have those questions been asked of the witnesses in this case?
Yes. and
Have you provided any information that's responsive to those
yes,
questions?
there's
What's the complaint, Mr. Bradel?
Well, that's what I'm asking, is if it's complied with. And
Just said it was.
I'm saying it was, and counsel got up and seemed to be wanting to correct me on that. And so here we are.
Okay.
So is it complied with or
Well, it's
not?
on the record. What else do you want?
The motion speaks for itself, Your Honor. I just want to know what the Commonwealth is objecting to.
Well, Mr.
They gave us a list, and we can go through it.
The list of questions that you asked?
Counsel objected to 2C. Have they ever refused to answer questions citing their constitutional rights? We had a little bit of a debate about that. I think that's, Judge, a firing offense. I believe that assistant attorneys general have been fired for that. I believe officers have been fired for taking the fifth.
Really?
I think it's
In the absence of
exculpatory.
transactional immunity, officers have been fired?
I think it's
You should read
exculpatory.
Carney versus Springfield, and I think you'll find that you're incorrect.
Well, Judge, I think that an officer that takes the fifth in this case about something else is saying, if I answer that question, a truthful answer will incriminate me. So I
Well-
think under Graham McFarland, I think that's certainly
The case doesn't say
exculpatory
it.
and discoverable.
The case doesn't say it. I don't agree with you. Carney versus Springfield says otherwise, okay? And I don't agree. So, Mr. Gubitosi, have you provided a list of the questions that you have asked to the officer, or can you, or will you provide the list of questions that you ask to defense counsel?
Of course.
Okay. And Mr. Bradel, if the answer to all of those questions is no, and they've asked them, I'm not seeing anything that would indicate otherwise in this case, then you need to examine the questions. And if you feel there's something that wasn't covered, then you can refine your motion. But I am not going to allow, and I don't think I agree with your view of the law, that whether or not an officer is refused to answer questions, citing constitutional rights is something that you're entitled to. In the immediate aftermath of critical incidents, officers often advantage themselves of the fact that the police department does not have transactional immunity so that they can have an opportunity to speak, sometimes within 24 or 48 hours. Happens all the time. And in fact, officers are often interviewed thoroughly thereafter. So the case does not say that if you refuse to answer questions, it is fireable. In fact, it says quite the contrary. The police department does not have the ability to grant transactional immunity. Only the Commonwealth of Massachusetts, the district attorney's office, or the attorney generals have that ability So to suggest that a chief of police or commissioner could fire someone for invoking their rights without giving them transactional immunity is incorrect. And so as to the extent you're asking for that, it's denied. Now,
The next one is D.
yeah,
Whether the officer is subject of a pending internal affairs investigation or any internal affairs investigations into the officer's conduct, whether these have resulted in sustained findings of misconduct. I'm not sure why there's an objection there.
Well, the way it reads is different than the way he said it.
okay,
If there is a sustained finding, absolutely.
sure,
And,
okay,
and there hasn't been in this case.
okay,
With any of the officers that are involved.
okay. So that's the answer to that. And as far as the other questions, it seems to me H and I are covered by the questionnaire, but J,
Well, no, if I might just, H and I, if you're gonna deny them, but they're different than what he's saying.
no, I is only, you only need to respond to I if there's been a finding by a judge that there was a misstatement in the search warrant affidavit, not whether or not defense counsel has filed a Frank's motion, because that happens routinely, and routinely the matters don't even reach an evidentiary hearing. And even if they do, it often doesn't result in a finding that there was any untruthfulness. So yes, if there has been a Frank's finding by a judge that an officer, any of these officers, made false statements in a search warrant affidavit, yes, you've asked about that, and yes, that has to be produced.
Of course.
Okay.
But H, if we can just get back to that, because we talked about that a little. And if the way counsel is talking about it, if there's been an adverse finding of credibility, of course we turn that.
Yes,
That's a no-brainer.
Right.
We do that.
But-
But that's not what that said.
no, I am not going to order the production of any motions to suppress that were allowed for any reason. First of all, it's almost impossible to ascertain that. And secondly, how many district courts in this county, Mr. Gubitosi? 7? Well,
Yeah, but you can ask the officer, Your Honor.
Well,
The officer is
he
right there.
has,
You can
and if
say-
there, I agree with you. If there was a finding that the officer made a false statement, you're entitled to that. But the fact that an officer thought that he or she had reasonable suspicion to conduct a pat frisk and a judge disagrees does not mean that the officer was found to be untruthful. But
I
yes,
agree
in
with you. We don't
in the
need-
course
we don't
of-
need to debate it. I agree with you.
okay, so I think we're fine. Now, Jay, you know,
I just have no idea.
I have no idea what that is.
Okay, and then they can answer that. They don't know about it, they don't know about it. That's the answer. I'm happy with that.
Okay. Now, is there, Mr. Gubitosi, when did you get meeting 35, the motion for specific discovery?
Friday.
Okay. Are you prepared to respond to it?
I can try to do that.
Okay. Is there anything in there that you object to?
Yes.
Okay, and what is that?
Again, there are portions of number 2. And the Commonwealth will provide all witness statements.
Okay.
That's pursuant to 14, just overbroad.
Okay.
Number 4A, excuse me, 4 is asking for any and all footage from the North Andover Police Department on June 30th, during the time of which Ms. Fitzsimmons was at the station. And we've already talked about that. They asked me a bit ago. They didn't ask me in time, so the footage is gone. But it just doesn't save longer than, I think it's 30 days.
Okay. If something doesn't exist,
But
then,
the last paragraph, the last sentence says, the name and contact information of any officer that interacted or observed Ms. Fitzsimmons at the time.
okay.
Well, she has that information. who she interacted with on
Right.
November 30th of 2025 at the station. So that's something.
Well,
that-
first of all, maybe I'm missing something, but other than in the interview room, when someone's advised that they're being recorded and you know, they're taped, I'm not sure there's,
No, I think this is, she didn't go to the PD after the event. She went to the hospital.
okay,
For the event, it's my understanding, and this is only from what defense counsel told me.
Yeah.
That she was at the station earlier that day.
oh, okay.
Had done something, I can't remember what, during the day.
Was that the station earlier, Mr.
But she
Bradel?
knows who she interacted with.
Okay, is June 30th the date of the incident, by the way? Okay. And when was she at the station and for what purpose? What time does the incident happen?
So Your Honor, the incident is, it's in the afternoon of the
Yeah.
30th. And prior to that, Ms. Fitzsimmons was at the North Andover Police Department for a CPR recertification.
I see.
She brought the baby with her.
Okay,
So we wanted the video
Yeah.
from the station. And on August 26th, I think the Commonwealth's going to have an issue with this, okay? On August 26th, we filed these arraignment motions.
Right.
Asking, we put them in abeyance except for some of the more obvious ones like
Right.
preserve notes, preserve video,
sure.
tell people who are video holders to hold on to the video. That was August 26th. So the
Okay.
Commonwealth was on notice as of August 26th.
Yep.
The video, I am fairly certain, was present and available then when they were given notice of this motion, and I believe the court allowed those preliminary requests.
Well, there are two issues there. First of all, though, when you say August 26th, was that filed in this court
Correct.
when she was arraigned?
Yes.
Okay. And Mr. Gubitosi, do you know, first of all, I don't know because not that familiar with the North Andover police station, whether or not they even have cameras that would have videoed the presence of the defendant at the station on that day.
They do.
Okay. And do you know how often those are recorded over?
Not at the present time.
Okay.
I did. When we spoke about it, I called.
Back in August?
It was on, I can't remember.
Okay, okay. So the issue then becomes whether or not the request was made. First issue is whether or not you're confident the video doesn't exist today.
Right.
Okay. The first question is, I think that the defense counsel is entitled to know when the video, how often they tape over. I mean, I hear,
I did tell him that.
right,
When I found out, I just can't remember right now.
but you can,
I can just suggest, Judge, if
Yeah.
I may, I looked at, counsel's trying to accommodate, so I
Right.
appreciate that. But on 9/18, counsel told me that they only had it back to July 5th,
okay. And you made the request,
8/26.
right, but that doesn't answer the last question, which is whether or not at the time you made the request, it still existed or not.
Right.
But
I-
Mr. Gubitosi, that should be easily ascertained.
Absolutely.
Sure,
I
okay.
think if you do the math, it looks like it is, and again, I
Is-
appreciate the Commonwealth's efforts to try to get it, but it looks like on
Yeah.
8/26, if you do the same math, 9/18, it goes back to July 5th, 8/26, you're going to be within the window of.
You may, I don't know. I don't know. Every video system that I've ever heard of, I've seen some that go 3 days, 7 days, 30 days. I don't know. But that's easily ascertainable. And Mr. Gubitosi is going to tell you about it, and then you can make of it what
I
you need to
appreciate
make of it.
And there's no motion before the court on
Yeah.
it. I just wanted to.
Okay.
factually Bring it up, Your Honor, that it's very important to the defense that we have that
All right.
video.
Anything else we can, in this motion, Mr. Gubitosi, that you object to that we can address today?
Yes, I could do that.
Please, yeah.
Number 6 is concerning disciplinary records for firefighters that responded to the home defendant or the Mass General Hospital.
And your objection to that is?
So the firefighters are not part of the prosecution team, if they're not in care, custody, and control.
I mean, you can file a Rule 17 for that, Mr.
Very good, Your Honor, that's
Bradel.
perfectly
I
fine.
think that's right. What else, Mr. Gubitosi? Anything else in this motion?
Number 9.
Yep.
All statements, including text, emails, voicemails, writings, or like the scene or among any civilian witnesses, police or prosecutors. I would just say it's overbroad.
Yeah, how, Mr. Bradel, how can the Commonwealth produce messages between people who are not, civilian witnesses?
Sure, I understand, Your Honor. The request should be really a little narrower, I suppose, which is whenever there's a police prosecution team member in the conversation,
Well,
then
that's
it
different.
should
I
be
agree.
discoverable.
Right.
So,
So statements, Mr. Gubitosi, of people who are,
Or statements that
yeah.
I'm obligated to provide in Rule
Yeah.
13, absolutely. I
okay,
agree with that,
Okay.
but not that.
and just, sorry, but,
No, I was moving on.
just one thing on that before you move on, Your Honor,
Yeah,
is
sure.
that,
Yeah.
it's our view, we viewed on the security video from the scene that officers are texting and calling all over the place at the scene, quite understandably.
sure.
But we just want the text messages, and we have information that there were communications between the father of the child and the police officers leading up to serving this warrant, leaving up the restraining order, rather, serving the restraining order, leading up to that. And there are communications that are between the father and the
Okay.
police that we want,
Well, if
which would
any
certainly
of
be
those
statements.
materials that are in the possession, custody, or control of the Commonwealth or the North Andover Police Department need to be produced. I can't, it's a little bit broad in the sense that, if there are people texting that the Commonwealth doesn't know about. it's
I
kinda hard
agree,
for them.
Judge. I don't even want to, I can cut to the chase on that.
Let me
Statements
suggest
that involve the
something
police and prosecution team.
here. I'm well aware of the fact that there's some discovery issues here, but they don't seem insurmountable to me. And they seem like something that could be worked out. The defendant's in custody. You are and have, as is your right, litigating the issue of hard detention. And my solution to that, it's not my decision one way or the other, but it's in front of the SJC. But I feel that this is the type of case that is tried in the district court every day. It's a serious case. All cases are serious, but it's not complicated. And I want to set a trial date sometime early next year, and we'll get another discovery compliance date in a few weeks. Mr. Gubitosi starting a trial December 1st. So maybe in late December, we can have another compliance date if it works for everybody to try to iron these things out, because, she is in custody. I'm cognizant of that. And so my solution, whenever, and we deal with this all the time, we spend sometimes more time dealing with the issues of pretrial conditions and release. And in the time we spend doing that, we could try the case. So this case looks to me, and I could be wrong, that it could be tried in a couple of days. And she's in custody. So if the case is tried and she's found not guilty, that's the end of it. If the case is tried and she's found guilty, that's a whole other issue. But the fairest thing, it seems to me, is to try the case as promptly as we can. So before your schedules get any more backed up, I want to set a trial date. We can always revisit it, but what about sometime in late January, February?
That's very fair, Your Honor, and I appreciate you saying that. And I wanted to ask maybe the first week of February.
Sure. Mr. Gubitosi, how's that work for you?
I have a murder starting on 26th of January, so if we can go to, I could do this the week of the 9th.
Okay,
That's fine.
does that work for you, Mr. Braden?
Yes.
Ms.
And that's-
Attorney
that's
Coakley?
Always with the caveat that I haven't checked with any witnesses.
Of course.
Sure.
And but this way we have a target date. Everybody can check with their witnesses. We can find out and iron that problem out now. And if there's somebody who needs an adjustment for a few days, a week, one way or the other, we can work on that. But the longer we wait to do it, the more backed up we get. And again, we're going to prioritize this case. She's in custody. Maybe she will be at that time, maybe not. I don't know. But at best, for your client, she's going to be on restrictive conditions, and that's a factor as well. So let's get a trial date now. Let's shoot for that. We'll schedule it for trial on February 9th. I think that's very reasonable. And let's set another discovery compliance date that everybody can live with sometime in December. Mr. Gubitosi, you expect to be tied up for a couple of weeks?
Yep, I think I can, the week of the 15th, I should be.
Okay.
I was going to ask for maybe the 18th along those lines. I think we're on the same
That's fine.
process.
We can do that, sure. We'll do the 18th. And my purpose that day,
Sorry, Judge, just a calendar issue, I'm sorry.
okay, all right.
Judge, 18 is a tough day, it turns out. Could we do the 19th?
I'll do it.
Okay.
If Mr. Gubitosi is available, okay. We'll do it. Now, and I want you to have a conference, which I know you will, to see if you can work these things out or to refine or narrow the motion. And we'll revisit those things that day. I have a Zoom that's coming from a different Norfolk that we have to get to right now. So it's either that or we get together late this afternoon.
Perfectly fine, Your Honor.
Okay.
I think we can resolve much of the rest of it.
Now, as far as your request, the last thing I'm going to cover is your request regarding transportation of the defendant. I allowed it today. I'm going to do it on a date-by-date basis. I mean, if the next date is discovery motions, I don't think that it's necessary to transport her. If you want us to try to do a Zoom, we'll attempt to do it. But the goal here, again, in fairness to the defendant and everyone else, is to get the case tried promptly. So we'll have a hearing that day. I'll try to, or me or someone will iron out all of these issues if we can, and let's keep moving. I don't expect, doesn't sound like you intend to litigate a motion to suppress in this case.
Correct, Your Honor.
So that removes one common obstacle to getting this done. So working with that, I think everybody's being reasonable in terms of time. Why don't you have a further conference, exchange written responses so that there's down the road, there's no misinterpretation, and let's see each other again in a few weeks. And I'll order a Zoom, Habe, if we can do that.
Thank you, Your Honor.
Okay? All right.
I think that'll be fine. If there's any issue, we'll file appropriate papers.
And if you have a narrower motion, or you can narrow the issues, file another motion, and I'll make sure that I get a look at it, or somebody will.
Thank you, Your Honor.
All right, thank you. Have a great holiday. All right,
Thank you, same to you.
okay.
Judge, would that be at 12 noon as well, the same thing, or does that?
My boss has to tell me that right here. Okay, she says noon, then we'll do it. Okay.
Welcome to Zoom, Government. Enter your participant ID followed by pound. You are in the meeting now. There are 2 participants in the meeting.